Hi everyone, we're gonna go ahead and get started. My name is Sansi. I am one of the staff attorneys here at IowaCASA. You can see my email address is on the screen. Before we get started, I do want to just mention one, we ask that all attendees fill out an evaluation. I put the link to that in the chat and I'll put it in there again a few times just as a reminder. You will need to click on that link before you leave the presentation so that you can access that.
And my name is Josh Opperman. I'm the other staff attorney here at IowaCASA. My email address, attorney@iowacasa.org, is also on the screen. And as Santi said, we do encourage you to get those surveys done when we end the program. Another reminder for everyone, some of this material, or actually really all of this material, is fairly heavy material. Emotionally, we'll be talking about sexual abuse as it relates to children and minors. And so we recognize that that could be triggering for some people, is probably unpleasant for everyone. So if you need to, please step away, take care of your needs as well while watching the program. And there are, I should mention, Sansi just dropped in the chat as well. Questions can be typed in the Q&A box on the Zoom webinar. So if you have questions, feel free to put those in there. We will get to them. Might not be immediately, but we will get to them as well. We'll be discussing criminal statutes today in the Iowa Code. So it's very important when discussing any statute to pay close attention to definitions that are provided in the law. A lot of times words are defined, and when a word is defined in the law, it means exactly what it's defined to mean. The common usage is not necessarily relevant on a defined term. So, we're going to use the term sexual abuse to mean what it means in the Iowa Criminal Code. Not necessarily what you might consider sexual abuse or what other people in our field might consider sexual abuse. We recognize that those things are bad as well. They might be illegal in other ways, but they're not necessarily sexual abuse under the Iowa Code. And then another piece of this, we're going to be going over statutes. You don't need to memorize the statutes. This is done in order to give you an idea of how the law works in Iowa and what might be illegal. We're going to be using the words as they appear in the law. So words like defendant, victim, etc. Those aren't necessarily the words we use in our everyday advocacy here. We use the ones that appear in the law as a point of clarity. And so that's just so that you don't get confused with what's in the law. I do see, Santi, we've got, I'll address the chat here. Santi, I think the next slide's yours anyway.
Sorry. I did want to mention real quick that we are recording this webinar. So if you don't wish to have your face or name show up, I guess it's a webinar, so that information probably is not showing up. But I do want to mention that we are recording this webinar, so it will be available later. If any of your coworkers weren't able to join us, they'll have access to the information, but the continuing education credits are only available for those lucky people who join us today. And I do want to pause real quick to make sure that we have the matter with the ASL interpreter sorted out before we move forward.
Yeah, so if I could get the interpreters to make a little bit of noise so that their videos pop up so that those who need interpretation can pin those videos.
Hello, this is Jeff.
Hello, this is Peggy.
And I apologize for the delay here. We're just trying to get our interpretation set up so that those who can, who would like to use it can see it. Not sure how to fix that. Let's see if I can pin it. No.
Josh?
Yes.
I think if you go to where the panelists show, it will ask if we give them permission to show, like allow a multiple pin. Can you see it? Like if you click on the camera where it says more.
Yes.
Next, yeah.
Oh, allowed a multi-pin.
Or it says add spotlight. You could also do that.
Okay, I think those are pinned now. Could somebody let me know if you're able to see those or not able to see them? Okay, looks like they're good now. So, all right, we will continue. I do just want to make sure that the presentation is accessible for everybody.
Yes. Thank you for your patience, everybody. Real quick, want to do a poll so we have an idea as to who's here with us today. It's like, ooh, we're almost there. All right. All right. Thank you, everybody, for joining us today. I appreciate that. And like we said, if there's any issues with technology, let us know in the chat box. We're all learning still. It's been a year and there are still things to learn about Zoom. So that's fun. But I'm going to start off talking about what sexual abuse is under Iowa law. And as Josh mentioned, what we consider to be sexual abuse within our field is probably not the same as what the Iowa Code defines it as. There are, very specific criteria for an action to be considered sexual abuse under Iowa law. And so the basic definition of sexual abuse in the criminal code is any sex act which is done by force or against the will of another, or if the other person is suffering from a mental defect or incapacity that makes them unable to give consent or to know right and wrong in relation to sexual activity. The other thing that makes a sex act sexual abuse is if the other person is a child. And we're going to go through more of those there's a few definitions on that on this slide that we'll go over here in just a minute. The first one is sex act. We have all these ideas of what a sex act is, right? Even our former presidents don't know what sex acts are, right? Under Iowa law, the sex act is how you see on your screen. It's sexual contact between two or more people, and any of those acts there that are listed. So penetration into vagina or anus, contact that is genital to mouth, mouth to anus, genital to genital, genital to anus. Any of those acts that are listed on the screen. It's a lot of acts. What you need to know is, what the law says is a sex act may not always be what we think of as a sex act. They did just recently in this legislative session expand the definition of a sex act to include touching somebody or touching your own genitalia or anus with a finger, hand, artificial sex organ at the direction of another person, and contact that is mouth to anus or finger to another body part. So those are additional acts that the legislature added to the definition of a sex act this year. The other part of sexual abuse, remember, a sex act or the other person is a child. Under Iowa law, for these purposes, a child is anyone under the age of 14. So there is a difference between how the law defines a child and how the law defines a minor. And where there's differences in those, it'll be noted. There are other parts of the section of the Iowa law where a child is defined differently, but for our purposes today, a child is anyone under the age of 14. When we talk about serious injury in this presentation, these are the things that we mean when we're talking about serious injury. This is how the law defines that term. And it can be disabling mental illness, a bodily injury that creates permanent disfigurement or loss or impairment of an organ or limb, or if there's a substantial risk of death because of that injury. Some examples of serious injury would include rib fractures, head injuries, and then there is a court case that says HIV, knowingly transmitting HIV to another person can be considered a serious injury.
All right, so now that we've got our sort of baseline definitions laid out, we're going to talk about how those definitions join together to make different crimes. So sexual abuse is a crime under Iowa law, and it comes in various degrees as crimes can sometimes be organized. The first degree sexual abuse is a sexual abuse. So any of those acts that we've talked about as sexual abuse, plus a serious injury. So if you have both, that is a first degree sexual abuse, and it's a Class A felony. Class A felonies can carry a penalty of up to life in prison. And so this is the most serious form of sexual abuse. There are special sentencing guidelines if the defendant is under the age of 18. That's because it's been found to be unconstitutional to have mandatory life sentences with no possibility of parole for minors. Sexual abuse in the second degree, slightly less serious than first degree, is a sexual abuse plus one of the following items: display of a dangerous weapon in a threatening manner, again, we're not going to define it here, but dangerous weapon is a defined term in the Iowa code. It doesn't mean just any weapon that is dangerous. Threat or use of force that creates a substantial risk of death or serious injury, even to another person. We mean a third person. So if you threaten somebody and say, if you don't do this sex act, I will harm this other person, your child or significant other, whoever it is, could be a stranger even, that satisfies that component of a second-degree sexual abuse. The third possible component is that the person harmed is a child. And again, we mean a person under 14 years of age when we're talking about a child in this context. Or the final one is that one or more people help and the sex act is against someone's will. So this is a situation where there are more than one assailants essentially who are forcing somebody to perform a sex act. Again, the code says against someone's will, so it doesn't necessarily need to be, keep your minds open about which person that could be. It could be any of those people potentially. And that's a Class B felony, any of those. That's still a very serious crime, carries a penalty of up to 25 years. And there is a possibility for enhanced sentencing as well. Sexual abuse in the third degree, and this is one that we actually see more often because, as you can see, it has many different things that could qualify it. But this is, I would say, probably the most common form of sex abuse in Iowa. It's done by force or against another's will, and the living arrangement is irrelevant. Marital status is irrelevant. Those two qualifiers are there because this is meant to differentiate it from the domestic violence statute, where a certain relationship is a prerequisite to getting a charge under that code section. So those items are not relevant in this section. Parties are not living together as husband and wife. So again, that relates to the domestic violence statute as well. If they are living together as husband and wife, it probably falls under the domestic violence statute, not this statute. And so you need that first component. It's not husband and wife, and it's against someone's will or done by force. And then you need one of these other things. The first one being the other person has a mental defect or incapacity that prevents them from giving consent. So we talked earlier about what that might be. There are lots of different ways that can occur. Or the person's 12 or 13 years old, or the person is 14 or 15 years old, and one of the following things. So again, it's complex. So if they're 14 or 15, they would need to be a member of the household. The defendant would need to be a member of the household, or related by blood or affinity to the fourth degree. Affinity means marriage. Or the defendant's in a position of authority and uses that authority to coerce, or the defendant's 4 or more years older. So that's a lot to unpack there. There are a lot of different pieces to that. And then the final piece of it is another possibility would be the victim's under the influence of a controlled substance at the time of the abuse, and the substance prevents consent, and the person performing the act knew or should have known that the other person was under the influence. So, oh, and there's actually one more. I apologize, I missed on there. The act being performed while the victim's mentally or physically incapacitated or otherwise physically helpless. It's very much like some of the other ones, but that would also qualify. This is a Class C felony, which is up to 10 years in prison and a fine of $1,000 to $10,000. And there are possibilities for enhanced sentencing as well on this charge. So we've looked at the statutes a little bit. A common question in this, because it does say in there, it mentions force a few times, and it talks about being against someone's will. Common question is force a requirement? The answer to that is no. Force is not a requirement. Physical resistance is not a requirement to show that an act was done by force. Force is only required, or it only satisfies elements. If something can be against someone's will and not be done by force, because as I'm sure all of you know, there are many ways that a person can be coerced that don't involve physical force. The court is allowed to consider all the surrounding circumstances when determining whether an act's done by force or not, or whether it's done against someone's will or not. Many times we'll see situations where courts will find that something was against someone's will, even though it wasn't by force.
So another crime that exists under Iowa law is incest. Unfortunately, we see quite a bit of this. Incest is defined as a sex act that is performed by basically an adult relative against a child relative. And that person knows that their victim is a relative of theirs. And generally speaking, it's only going to apply to a defendant who is not themselves a child. This is a Class D felony, and person convicted of incest could face up to 5 years in prison. Someone asked about statutory rape. Here it is. So statutory rape is a little complicated because it could be sexual abuse in the first degree, second degree, or third degree. And Josh went over what those are a few slides ago. Basically, statutory rape is kind of a special kind of sexual abuse that happens, in the circumstances that are listed there on the slide. Statutory rape can occur and then be charged as sexual abuse in this first, second, or third degree. Another crime, sexual exploitation of a minor. This is essentially the child pornography statute. It may be a Class C or the Iowa child pornography statute. There is a separate federal statute, which we won't get into today because this focuses on Iowa law. But sexual exploitation of a minor can be a Class C or D felony or an aggravated misdemeanor. Seems to me like those would be something that you might want to punish a little bit more, but it may be as little as an aggravated misdemeanor in Iowa. And again, this code section applies to minors, which are people under the age of 18. Another law that exists in Iowa is lascivious acts with a child. This applies to sex acts that are done with a person who is under the age of 14, and the other factors that you see on the slide are met. So the person committing the act must be 16 years or older. The victim must be 14 or younger, they're a child. And then the act must be performed with the intent to arouse or satisfy the sexual desire of either person. Iowa law breaks it into a Class C and a Class D felony, depending on some of the other circumstances that may also accompany the sex act between the parties.
All right. The next crime that we're going to cover is indecent contact with a child. This one is only applicable to perpetrators who are more than 18 years of age. Excuse me, losing my voice a little bit here. But an important point is that consent is irrelevant in this case. So it needs to have the purpose of arousing or satisfying sexual desires of either party, the person who is over 18 or the other person. And it involves various acts which are not defined as sex acts in the code, but are still sexual in nature. Those include fondling, various forms of touching, both above or below clothing. Well, actually, I'm sorry, only above clothing. Below clothing would be a sex act. I apologize. And then soliciting or permitting a child to do those things as well, or soliciting a child to engage in the various sex acts. This would apply when those sex acts don't occur, but you've solicited to try to get them to occur. This is an aggravated misdemeanor, so it's a little bit less serious of a crime. Aggravated misdemeanors typically carry a penalty of up to a year in jail. And then this would also apply if the perpetrator is 16 or 17 and the victim is more than 5 years younger. In that case, it would be tried in juvenile court as a delinquency matter, not in the criminal courts like it would be if the perpetrator were 18. Lascivious conduct with a minor. This applies again when perpetrators are over 18 and they need to be in a position of authority. The victim would be a minor, so someone under 18, and the action would be for the purpose of arousing or satisfying sexual desires of either party. Again, could be the minor, could be the perpetrator, could be both. Consent, again, is irrelevant. And this is where a person forces, persuades, or coerces a minor to partially or fully disrobe. So essentially, this is just the act of causing the minor to get undressed, or that basically. It's a serious misdemeanor, so slightly less serious than the previous. And then next we have sexual exploitation by a counselor, therapist, or school employee. You'll notice we've got et cetera on there. This law has also been amended to include even more parties in slightly different ways. The counselor or therapist, this is a situation where there's an emotional dependence. The professional knows or should know that the person's unable to give consent because of their emotional dependence on the counselor or therapist. It does require mental health services be provided. That includes treatment, assessment, or counseling. For that reason, advocates would not fall under this role most likely. They don't provide treatment, assessment, or counseling in the form of a mental health service. It's a slightly different relationship. Not that we would recommend that you have any relationship with your clients, obviously. There is a 1-year limitation on that as well. This is a current or former patient, and the actions would be for the purposes of sexual arousal of either party. School employees are slightly different. So any sexual contact between a school employee and the student for purposes of arousing either party would qualify. This is something you tend to see high profile in the news. Again, the victim in this case could actually not even be a minor. They may be 18 years of age, but because of the special relationship between school employees and students, it's prohibited by law. And then there is a new law this year, and that's what I was talking about previously, that expands this crime to include other adults that are providing training or instruction. There's not a lot of guidance on what training or instruction means. So at this point, we assume it means almost any training or instruction. The conversations around the law when it was being enacted revolved primarily around athletic trainers and firearms instructors. I think some of the high profile cases having to do with Olympic athletes probably were part of the motivation for this. But these are people who are not school employees, but are still paid to provide training or instruction to minors outside of the school setting. And this can be anywhere from a Class D felony to a serious misdemeanor. It depends on the circumstances. So this is a real life example that we have on here. A Mahaska County school teacher was arrested and charged with 2 counts of lascivious acts with a child, 2 counts of indecent contact with a child, 4 counts of lascivious acts with a minor. The question arises then, why not sexual exploitation by a school employee? These crimes, were over a number of years, so it's hard to say exactly what the details of all of them are, because obviously there are confidentiality issues there.
Yeah, and I'll just add, that when these things hit the news, we don't have all the details. This was one very recent example of what happens when a teacher, abuses their power over students. And you can see how the charges can be stacked. Any of these charges may apply to the same incident or act, but it may essentially tick more than one box when it comes to the actual crimes. And so you can see how the county attorney, how they charged that. They've stacked up the charges quite a bit, probably because they're trying to make room for a plea agreement, or they're hoping that there's more evidence in one case or one incident than versus another one. But this is a pretty typical of these situations where you have a school employee who has abused a student and is being charged as a result of that abuse.
And again, it's possible that more charges could yet be added because this is pretty recent.
So we wanted to give y'all a quick note on statutes of limitation. We get questions on statute of limitations quite a bit. It's pretty common for survivors to experience sexual abuse, especially as a child, or as a teenager, and not be in a place where they want to pursue charges or pursue a civil case, things like that, until they've dealt with some of the trauma that comes along with the abuse that they've experienced. There are statute of limitations for the crimes that we've talked about today. A statute of limitation is the time period that's dictated by the law in which charges can be brought, which means after the statute of limitations has ran, that claim or that charge can no longer be filed. They're barred forever from filing that claim. There are some exceptions to the statute of limitations or certain circumstances where the statute of limitations might be extended, such as if somebody was under a disability for a period of time. Generally, the statute of limitations doesn't start tolling until the person is 18, at least for civil cases. Depending on the crime that's being charged, the statute of limitations might be 10 or 15 years, depending on the situation. And as always, there are exceptions to every rule. There are certain circumstances, like I said, where a statute of limitation may be extended. If you have a question on a statute of limitation for a specific client, please feel free to contact us. I don't know that we can answer those questions right now, but it is a question that comes up a lot. And so if you do have a question regarding a specific client now or in the future, feel free to contact us. Some of you may have heard that there was a new law regarding expansion of the statutes of limitation in this last legislative session. So ignore everything that I just said, because there's a new law now that limits the statute of limitations for criminal cases only. So those statute of limitations that I was talking about, those don't exist anymore. I forgot to delete that slide, so I apologize. And before I send out the PowerPoint, I'll make sure that that's deleted. Just make a note. So there was a new.
That there were a couple of crimes in there that it would still apply to.
Yeah.
Mostly the lesser ones.
Yeah. In general now. There's a new law that eliminates the previous statute of limitations for the cases that are listed here on the slide. Sexual abuse in the first, second, or third, when that's committed against a minor, incest, sexual exploitation by a counselor, therapist, school employee, or adult providing training or instruction, and human trafficking. So those are the crimes that no longer have a statute of limitations in Iowa. That those charges for those crimes can legally be brought up at any time. However, one big caveat to this new law is that just because this new statute, this new elimination of the statute of limitations is on the books, doesn't mean that more of these cases are going to be prosecuted. Unfortunately, there's no guarantee. And that's because, it may, if a statute of limitation applied to a case before and now it doesn't, that still means that the case is 10 or 15 or more years old. That's a long time in the legal world to bring a case, any case. Even murder, that's a long time. Witnesses move away, witnesses pass away, case files get lost, DNA gets corrupted, evidence goes missing. There's all sorts of reasons why a prosecutor may decide not to bring a case, even within the statute of limitations. But outside the statute of limitations, the farther you get out from that, generally, the less likely it's going to be that a county attorney is going to be willing to file charges for that incident, and or that law enforcement will be willing or able to investigate that report. So, this may apply to one or two cases. It's not going to be something that generally applies, unfortunately, to a lot of the cases that you and that we talk about or hear about. So, again, if someone, if a survivor comes to you and says, I heard there's a new law, what can you tell me about that? Feel free to direct them our way. We can talk to them about that. But we just want advocates to know, you may hear about this new elimination of statute of limitations, and it sounds really good, but practically speaking, it may not be overly helpful to survivors, unfortunately.
And we did just get a question in the Q&A asking about the 3-year DNA rule. I believe the rule is that if new DNA evidence is discovered after the statute of limitations runs, there's a new 3-year statute of limitations from that time period. So that basically came about when DNA evidence first became invented. They wanted to open up a lot of cases that they previously were time barred. And I would also add to the statute of limitations discussion, it's good practice from an advocate standpoint to, maybe temper expectations with some of your clients, because they may have heard, oh, the statute of limitations has been removed, and they're thinking, I'm going to rush out and finally get justice for that thing that happened 30 years ago. Very unlikely those cases are going to result in criminal charges. So again, a lot of people have the presumption that they have the right to press charges, and the court has to hear those cases. And that is not the case. It's absolutely the prosecutor's determination whether charges will be filed or not.
Mm-hmm. And I do want to emphasize then too that this applies to the criminal statute, not the civil statute. We get questions regularly about, people seeking damages in civil court for a past sexual abuse. Those statute of limitations still apply.
Yeah. And the statute's 2 years, usually 2 years from the time you turn 18, if you were a minor at the time. So it's not very long at all. Most survivors are, I would say, generally speaking, not ready emotionally to tackle that before the statute's already run. So unfortunately, and we are, as an organization, we have been in support of bills to remove that civil statute limitation, or at least modify it. It's not yet happened yet. So another thing we get a lot of questions about is the sex offender registry. And the sex offender registry is pretty complicated. There is a statute that relates to it. There are also some regulations. Generally speaking, if you are required to register as a sex offender, it's usually either for a period of 10 years or for life, depending on what you were convicted of. And so again, this is another reason why sometimes prosecutors will change a charge in order to get a plea agreement. They might say, well, I could get you for whatever crime that has a lifetime reporting on the sex offender registry, but if I amend the charge to this other thing, you'll only be on it for 10 years. It's a negotiation point sometimes for prosecutors. So there are 3 tiers in the sex offender registry. Tier 1 is the least severe, and then they escalate from there. Tier 1 it does include sex offenses committed against minors. Also includes receipt or possession of child pornography. Tier 2 would include lascivious acts with a child, solicitation of a minor, indecent contact with a child, lascivious contact with a child, sexual exploitation by a counselor, therapist, or school employee, or also adults providing instruction now, which is a new class, if the victim is 13 or older, incest, sexual exploitation of a minor, etc. So the bulk of the crimes there are in that section. And
Yeah,
then
and I
go
don't
ahead.
mean, I did not mean to interrupt. I did want to point out that these are just some of the sex crimes that are included in these tiers. There are dozens in each tier that that could be included, that somebody could have to register as a sex offender if they're convicted of that. So these are just some of them. They're the ones that we've talked about, and probably the ones that you see most often.
And you may notice that some of these appear to be duplicated in various ways. It's because the facts of the case matter, the age of the victim at the time, the age of the perpetrator at the time, those kind of things. So tier 3 being the most severe, usually specifically mentions offenses committed by someone over 14. So if you're under 14, you're unlikely to get a tier 3 event. Otherwise, a lot of the same things that are in tier 2 would be a tier 3 crime. All right. So we have had questions in the chat about age of consent. This is the time that we get to that age of consent piece. We get a lot of questions about age of consent. So the age of consent, if anyone doesn't know what that term means, is the age at which a person is legally competent to agree to sexual activity. In Iowa, that age is 16, generally speaking. That's in section 709.4. So under the age of 16, sex acts may be sexual abuse in the 3rd degree. If there's more than a 4-year age difference, it also may be sexual abuse in the 3rd degree. Some relationships, age might be irrelevant. So incest, it's not going to matter whether you're 16 or 14 or any of those things. The mental health counselor, school employee, adults providing instruction angle, age isn't relevant for that either. So the sort of moral of that story is that this is complicated. It's not just once you turn 16, you're able to consent to whatever you want, and it's fine. 16 is the general age, but there are a lot of caveats. So let's talk about a scenario here. Actually, Santi, I think this is yours.
Sorry, we try to divvy things up so they're equal, and every once in a while we get in the groove and want to step over someone else's slides. So we're gonna, I think you all are doing great. I can't see you, I can't hear you, but everyone here I think is doing great, paying attention. We know that going through and wading through statutes and all those different factors and everything is no one's idea of fun, not even ours. And so, if you're still with us, thank you. You're doing a great job. Statutes are boring, and now hopefully we're going to get to something that's maybe a little bit more helpful. We wanted to talk to y'all about a few different scenarios, some of which we've encountered or heard about, that you may see that apply to the statutes that we've talked about today. So consent scenario number 1. Jamie is 13. Alex is 16. Alex has no position of authority over Jamie. Jamie is mentally healthy and is not under the influence of any drug. They aren't married. Jamie consents to sex with Alex. And we're not going to make you go through the whole analysis, but some of these may ring a bell with situations that you've run into in the past or in the future. And so we just kind of want to give you an idea of some real world scenarios. So in this situation, even though Jamie said, yes, I want to have sex with you, Alex, Alex has committed sexual abuse in the 3rd degree. And that is because Alex is basically too old and Jamie is too young. Under Iowa law, a 13-year-old is not considered legally competent to consent to sexual activity.
That one actually happens quite a bit in schools. It may seem like most 16-year-olds are not trying to have sex with 13-year-olds, but you'd be surprised how often this happens where, a high school sophomore or junior has a freshman girlfriend who's kind of young for the class, that sort of situation, and that kind of thing. It does happen quite a bit, and it could be totally consensual among the parties. Often it rises to criminal charges when a parent finds out and is upset about it. And we find that these have disproportionate enforcement against, students of color. Might also be disproportionately enforced when it's a same-sex relationship. Any of those kinds of relationships that you can imagine that the parents may not be supportive of. You tend to see this.
Candace asked in the chat if this would be filed in juvenile court, and leave the answer.
I think the answer is no on this one. Yeah, I think. I want to say all sex abuse in the 1st, 2nd, or 3rd degree are all filed in adult court.
If I was Alex's attorney in this, I would certainly argue to have it transferred to juvenile court, I think, because Alex is a minor, and if Alex has no other criminal history, is good at school, is involved in things, and there was there was consent, and Jamie is like, I don't want this to happen, then, and when I say I don't want this to happen, I mean Alex charged with a crime, I would certainly say try to find a way to have Alex's case transferred to juvenile court. So that Alex doesn't have that on their record, and that maybe, they do community service or participate in one of the court programs or something like that.
And even if this charge is not one that's eligible for juvenile court, the prosecutor could possibly be persuaded to amend it to a charge that is fileable in juvenile court. And they may be willing to do that. In fact, they may be eager to do that, because the penalty for a sex abuse in the 3rd degree might not be a penalty that they're thrilled about imposing on a minor. It might be jail or fines or things like that that are not great solutions for minors. Whereas if you're in juvenile court, you could be potentially on probation for years, and it could have a much greater impact on whether you commit crimes in the future. This one, Taylor's 15 years old. Jordan is 20 years old. Taylor tells Jordan it's okay to have sex with each other, and they have sex. Jordan holds no position of authority over Taylor. Taylor's not under the influence of any drugs. It's not stated, but they're not married either. So under Iowa law, Jordan has committed sexual abuse in the 3rd degree. This one is pretty similar to the other one. However, it's a little bit different because the sex abuse in the 3rd degree statute includes that 14 or 15 category. And in this case, Taylor is 15. Because Jordan is 4 or more years older, it does qualify. If Jordan had been 18 instead of 19 or 20, there'd be no crime.
We had a question in the Q&A box. I believe it was in regards to consent scenario number 1. asking if this is due to lack of sex education, if they did not have the proper understanding of consent. And that could possibly, I mean, it's tricky, right? Because, you know, a 13-year-old is not legally capable of giving consent to a sexual activity. They can certainly say, yes, I want to have sex, right? And to kids and teenagers and even adults, hearing from somebody, yes, I want to have sex, and they're excited about it, that's consent, right? That equals consent. You know, even the sex education programs, like that's what we talk about as consent. It gets complicated when it's you know, these different ages, these younger teenagers, people who are under 14 years of age. You know, it could be said that they gave consent, but that consent was not valid because of their age. So I hope that answer makes sense in its own way.
I tend to say that's ineffectual consent, you know, or they're intending to consent, but they're unable to.
Mhm. Consent scenario number 3. Jamie just turned 18. Alex is 14. At a party, they both drink, and they end up making out, and they fondle each other. Has Jamie committed the crime of indecent contact with a child? No, because Alex is 14. If Alex was 13, it would be indecent contact with a child, because under 14, they are legally considered to be a child. And if Jamie was touching Alex over the clothing, then that would fall under the definition of indecent contact with a child. Have either of them committed any other crime? Probably not. Kissing and fondling don't fit the definition of a sex act under Iowa law if it's over the clothes. And Jamie is not in a position of power over Alex, which would be a required element for lascivious conduct with a minor. So you can see how these situations can get super complicated. And another reason why none of you are being expected to memorize or analyze any of these statutes. We're just trying to make y'all aware of what some of those crimes are that can be charged in Iowa under current law.
Yeah, sometimes it's enough just so you have a thought in the back of your mind that, oh, I should find out whether this is a crime or not. That's really the level that we're hoping to get to. Then you'll be able to give us a call and we can analyze the specific situation for with you there on the phone.
There may not be much we can do, but if you have that question.
Yeah, not always. Yeah. All right. Consent scenario 4. Charlie is 13. Austin is also 13. Curious, they mutually engage in sexual touching, but no intercourse occurs. Under Iowa law, they may have both committed third-degree sexual abuse. So this is one that surprises a lot of people. But under 709.4, a person commits third-degree sexual abuse if they engage in a sexual act with someone they're not married to, if the person's 12 or 13 years of age. So because they're 12 or 13, it doesn't matter in that statute that the other person is also 12 or 13. In this situation, we don't know exactly what touching occurred, so we can't tell whether or not a crime was committed based on just that information. But if we figured that out, then we would know whether a crime was committed or not.
Hold on, I'll back up.
We got a message in the chat that you guys can't see, but it asks, in the Taylor scenario, if in fact she conceived technically at age 15 and hid the pregnancy until or delivered at age 16, could her parents still file charges since it's within the statute of limitations? So statute of limitations on these types of scenarios always don't start until you turn 18. But a lot of the statute of limitations have been removed. Another thing I would note on here is that the parents don't file charges. Only the prosecutor does. So the prosecutor could just say, "No, I'm not interested in that. Go away," if they want to. Hopefully they don't do it that way, but you know, they may not have time for it and they may not be interested in it.
Mhm.
And
Yeah,
you know,
and the
parents can
9
report it, not necessary.
the 9 months in that situation isn't going to cross the line from yes, this can be charged to no, this can no longer be charged.
Yeah.
So,
Yeah,
and-
it's a situation of many years usually, and always you have to be 18 before it even starts.
So the last consent scenario for this portion, Jesse is 18 years old and just graduated high school. Morgan is 17. Jesse was hired by the school as the assistant soccer coach and coaches the team Morgan is on. Jesse helps makes decisions on who plays in games, who makes varsity, and other important decisions. After a game, Morgan complains to Jesse of a thigh cramp. Jesse asks Morgan to pull up or remove their pants. Morgan takes their pants off, and Jesse, who has no physical therapy training, performs a massage on Morgan's thigh. Morgan's parents find out later and report it to the school and to law enforcement. Have any laws we've discussed been violated? So I want to say that I typed this up before the new law was passed about the adults hired to provide instruction or training. If that law had not been passed, the answer would be probably not. However, because that new law has been passed now, I mean, Jesse might be in a little bit of trouble. There's no indication here, though, that there was that the touching was because of to arouse or sexually satisfy either party, right? Jesse gave Morgan the option as to if they wanted to pull up their pants or pull them down. Now, Jesse might be in trouble if the school has a policy about these sorts of things. Jesse might get fired. There might be school policies in place where Morgan or Morgan's parents, if they're the ones who are upset about it, file a complaint with the school and Jesse gets fired. So
the other thing I would say on this one is, you know, it's possible that Jesse could still be charged because of course Jesse's going to say, well, this was a massage given for therapeutic purposes. It wasn't sexual in nature. Even if it was sexual in nature, Jesse would probably say that though, right? So I mean, Jesse may have had the purest of intentions, but could still get charged, and in fact could be wrongfully convicted even. It would be up to a jury to determine whether they thought it was sexual in nature. Now, because it's questionable, it's possible a prosecutor would say, well, I'm not willing to stake this on a jury trial for maybe that was a massage and maybe it was sexual. I think most prosecutors probably wouldn't try that case. All right, alcohol. So alcohol is complicated. You know, as advocates, we would like to say if someone's intoxicated, they can't consent. And certainly that's our position. from a a prevention and sexual assault advocacy standpoint. But from a legal standpoint, that's not really the law. It's much more complicated than that. And in fact, I would say that many adults, if not most adults, have engaged in sex acts while intoxicated. And generally, as a society, we think that most of those were probably okay. So the law says if you're mentally incapacitated, means you're temporarily incapable of controlling your own conduct. If you're physically helpless, you're unable to communicate any unwillingness to act because of being unconscious, asleep, whatever it is. If you're physically incapacitated, then you have some sort of impairment or disability causing you to not be able to resist or flee, or you could be physically incapacitated by a restraint or something like that. So courts have said that, additionally, courts have said that some level of awareness during assault doesn't mean that you're not incapacitated. Just because you have some awareness doesn't mean that's not incapacitated. So all that is to say that those four or three, I suppose, factors: mental incapacity, physically helpless, physical incapacity, those are all factors that would be considered by a court as to whether or not you are capable of giving consent. Certainly how intoxicated you are is an indication of some of those, but there's no bright line of once you are intoxicated, you can't consent. It's really a judgment call on every single one of them. Mandatory reporting. So we do also do separate trainings only on mandatory reporting, but we just include this in here because we tend to get questions about it when we're in this training. Mandatory reporting is triggered when there's a reasonable belief of child abuse by a caretaker, if you are a mandatory reporter. So sexual abuse of a child does not automatically require a report for mandatory reporters. I should back up and say, most of you indicated that you are sexual assault or domestic violence advocates or a dual advocate. Those positions are not mandatory reporters, and in fact are prohibited from reporting in most circumstances. So this
Under
is
the law.
under the law, yeah. And this is a more of an academic distinction here, or for those of you who may be some other thing like a therapist, acting as a therapist and not an advocate. So sexual abuse of a child does not automatically require a report. You need to ask, was the person who committed the abuse responsible for the care of the child at the time the abuse occurred? So was it sexual abuse of a child by their caretaker? And then the other question would be, did a caretaker fail to act to protect a child from sexual abuse they knew may occur or would occur? So, is this did they know about it, essentially? So if a caretaker did the act or allowed the act to happen, it could trigger a mandatory report for those who are mandatory reporters, which is not the vast majority of us. Otherwise, it wouldn't. And there are all kinds of reasons why you would maybe not want to report.
So this section, we're going to talk about, we get a lot of questions on when minors and children can consent to medical procedures, treatment, and when they can consent to advocacy services. So we're going to talk about medical services first. We get a lot of questions on this. Generally speaking, minors can consent to emergency services, contraception and family planning, STD care, partner therapy for STDs, HIV/AIDS care, drug and alcohol treatment, as well as treatment for sexual abuse or assault. So the forensic exams at the hospital. And they can also consent to tobacco cessation programs. One question we get that is messy and that you may end up having to deal with as an advocate, especially if you do hospital calls. Sometimes you run into a situation where a minor presents to the hospital with parents or guardians, and the parent or guardian is insistent that the minor undergo a forensic exam because they think something happened or they know something happened and they want proof of that. In that situation, it should be, and in our viewpoint, is 100% up to the minor, even though they're a minor, whether or not they undergo that treatment. We feel that it is unethical to force a minor to undergo such an examination without their consent. It's re-traumatizing, it's re-victimizing. But that is a question that we get where a parent or guardian wants them and is insisting on it. It's not up to them.
And most hospitals won't do it either.
Yeah. But as an advocate, that may unfortunately be a situation where you get put into, and having to explain to a parent, why you're not forcing the child to undergo something that could prove that they were sexually abused and by whom. So it gets a little tricky, but we get that question, I think, more than we should, because parents and guardians get passionate about those sorts of things happening to their children. So
it's tough to explain to parents that not only are most of these not reported, but it's a high likelihood nobody's going to jail for this. So that's how it is.
Yes. So we do want to point out that there is an important distinction between being able to consent to medical services and being able to ensure confidentiality for those services. As an advocate, you're confidential. If you go to the hospital, that's confidential without some sort of release, right? That doesn't necessarily apply to the hospital staff or the medical professionals. Depending on the kind of treatment that occurs, there may be a requirement that the hospital staff notify parents or guardians when the minor presents to the hospital for treatment for certain things. Also, there's an important distinction between consenting for a medical service or treatment and consenting for insurance to be billed for those services. Generally speaking, minors are not going to be able to present to the hospital and say, yeah, bill our insurance. Unfortunately, it doesn't work that way. So that can get a little tricky. And again, that's a reason why confidentiality may not necessarily be guaranteed. If a minor goes to the hospital to get treatment, that's not just covered and that is billed to insurance. Really the only thing that there are certain things that the Iowa law says state funds will pay for, and one of those is the sexual assault exam. So a survivor should never get a bill for a sexual assault exam. If that ever happens, please let us know. That's usually a mistake on the hospital or insurance part. So, and again, just because the law allows for minors to consent to certain services does not mean every provider will provide those services. There may be any number of reasons why a minor presents to a hospital for contraceptions, for example, and the hospital says no, or the medical provider says no, we're not going to give those to you because you're a minor. There may be policies in place at that particular facility that doesn't let them do that. Again, this is a situation where if you have questions on a specific case, please contact Josh and or I to discuss those. We talked about this, about a child undergoing a forensic exam. When the survivor tells you they don't want an examination, when the parents or guardians are insisting on it. So again, we feel that that is not ethical. There's the likelihood that the medical professionals may not even want to do it at that time. And the other complicating factor is, what if law enforcement shows up? And there's, pressure from law enforcement to also have that examination. What it boils down to, and all of you know this as advocates, it's up to the survivor, regardless of their age. First, we don't force people to undergo any exam. Second, especially even if they're a minor, and then on additional to that, parents don't get to dictate the advice, consultation, or information that advocates provide to the minor. That's something that we deal with as attorneys all the time. We have parents who want to be involved and have their own ideas as to how things go. That they don't dictate those. They can be, an important resource or support for their minor child. They can help remind their child to get back to us, those sorts of things, but they are not the decision makers.
All right. Advocacy services. So we got this question today, and we always do basically. When can a child consent to meet with an advocate? So there's no limit. Meeting with an advocate doesn't require consent. It's just a conversation, right? You're not providing medical treatment, etc. So our position is, as long as the child is able to understand confidentiality and the obligations of the advocate or whatever, it's fine. Can a parent or guardian or other family member provide consent for advocacy service? It's not needed to get consent for advocacy services. Now, that might be different for services such as therapy, which is a medical treatment, but for advocacy services, that's not a service that requires consent from a legal standpoint. Can minors sign releases? Minors can sign releases as long as they're able to understand the release, the confidentiality involved, and what the effect of waiving confidentiality is. It needs to be an informed consent. They would legally be able to sign that release, and it wouldn't require a parent or guardian to sign as well. That's based on Iowa law, however. That doesn't take into account your agency's policies, which have other considerations like insurance obligations or funding stream obligations, those kinds of things. So you should always follow your own agency's policies, confer with your supervisor, etc. I want to back up in the chat here. I had a question I want to make sure I address that's relevant here. So it says, at what age can a minor legally sign their own release of information to prevent parents from gaining information? So again, the release isn't needed there, but the question is basically when can the child prevent parents from getting information? Our take on this is that the laws regarding advocates essentially dictates that you can't tell the parents anything without a release. The parents aren't part of this. Once the child's able to understand the confidentiality and sign a release, that's the child's choice to do that if they want their parents involved. I've also had cases where you have one parent who's on board with some manner of treatment, another parent who's not, or I shouldn't say treatment, but some course of action, and the other parent who's not. That is a complicated situation and requires a deeper analysis. I'd encourage you, if you have any of these issues, give us a call and we'll give you some advice regarding it. And you can loop your supervisor in if that's possible without breaching confidentiality as well.
Yeah, and that comes up a lot when parents are divorced as well as the other piece that comes up a lot when parents are divorced is treatment, mental health, and medical treatment for certain things. So in any of those scenarios, please feel free to contact us. We'll talk to you about those and go over those in more detail depending on the circumstances of the situation.
Yeah, we really need, in order to figure those out, we really need to know things like who, is there joint custody? What exactly is the person requesting? Those types of things are all relevant. So, yeah. Another thing that we want to be sure to be clear about is even if a survivor's experience meets that definition of a crime, we don't get to name that experience and label it for the survivor. So the example we give here in the case of incest, the survivor may know something was wrong, but having someone tell them that they're a victim of incest could be traumatizing, and it's not necessary. If you may warn them of that if they say they want to report to the police, that might be appropriate. But and you all know this, just be sensitive about what words you use with survivors and how you put the law's sort of framework of ideology over their experience, because they may not choose to engage with the criminal justice system, and most of them won't choose to engage with the criminal justice system. And outside of the context of that criminal justice system, this framework of terms is not useful.
I put the link again in the chat box for the evaluation. We ask that you fill that out and that you click that link before you leave the presentation, before you log off. We do want to allow you time to ask questions. Before we do that, start thinking of your questions, but I also too want to remind you of what our grant currently covers. We are currently funded to assist survivors of sexual violence, which includes rape, assault, abuse, and stalking, when the survivor is over 11 years old. We're able to provide direct legal representation in those situations. Our focus for the grant currently is on rural areas, but we do also provide services to non-rural areas of Iowa. Some of the areas of law that we can help with, we can assist with, include landlord-tenant matters. We're still getting and helping with a lot of sexual misconduct and Title IX cases in schools. We can also help with credit, consumer credit issues. Let's say somebody was being stalked or was sexually assaulted and missed paying a bill or something like that. We could do what we can in that situation to try to mitigate that, to try to lessen the negative consequences on the survivor because of that. Unfortunately, we are funded to provide, not unfortunately, we are funded to provide services to those whose sexual violence occurred in a non-intimate partner setting. So we're currently not funded to help in cases of divorce, child support, child custody, if it occurred within an intimate partner relationship. What am I forgetting, Josh?
Well, I would just say that that's mostly because that would fall under the domestic violence statutes, and the domestic violence organizations in the state are funded, some of them at least are funded for that work. Mm-hmm. And so our grant is specifically targeted in this way to provide services where there's a gap.
Mm-hmm. No, it doesn't mean if someone comes to you and says, I was sexually assaulted by my partner, you can still contact us. We can direct them towards resources, walk them through a process, answer questions for them. Anything that doesn't fall under us being able to provide legal representation, we can still provide resources and referrals and answer questions and those sorts of things. So, don't hesitate to contact us with those questions.
For sure.
Speaking of questions, again, everyone, thank you for sticking with us. We know this is not a fun presentation to sit through. It's a lot of boring information in the form of legal statutes and laws. So, thanks again for joining us. And if you have any questions, you can type them in the Q&A box. And we'd be happy to answer those. If you think of a question later, you're welcome to email us.
Yeah, and again, our emails are attorney@iowacasa.org and legal@iowacasa.org. Also, if you asked a question previously and you don't think that we answered it as fully as you'd like it answered, feel free to reach out. Oftentimes there are just more pieces to it that need to be figured out before we can answer it. Those emails are in the chat. Santi, thanks for putting those in there. And I'm not seeing any new questions in there. So we may be good to go.
Yeah, so if you don't have a question you have clicked on the link to take the survey, you're free to go. Again, we appreciate you being here and appreciate the work that you do. And I know we've said it 20 times already, but please do not hesitate to contact us with any questions that you have, whether it's about a particular case or a general case regarding Iowa law in the sexual assault realm. So. And we'll just wait for a few minutes and let people log off or ask questions. We'll just sit here. Okay, we will go ahead and end the presentation and get everybody logged off. let us know, like I said, if you have any questions. Thanks, everyone.